Well, why don't you go get it?
I had no way of getting it back over here.
What do you mean?
It's not,
Doesn't it run?
it needs work.
It doesn't run.
Well, it did run when I bought it. That was years ago, so.
It doesn't run now, right?
It's a real old
It
motorcycle.
doesn't run now.
No, it's a real old motorcycle. It's a 1980 Honda 500.
There's nothing about this relationship that works.
Yeah. Personally, I think Bob should just drop this case, and we should just walk
Well,
away.
he probably thinks you should drop your case.
I'd be fine to drop it if he drops the case. What about you, Bob? What do you think? You want to drop the case?
What do you think, Bob?
No, sir.
No, you're not going to drop the case?
No, sir.
Well, I think I'm going to make you drop it, Mr. Doherty.
Bob, drop the case! You've got no written lease and you're being sued for double! Oh, I don't know what you're thinking. The conclusion after this.
When someone abducts a child, they're not about to advertise it. But we will. Sign up at wirelessamberAlerts.org to get free Amber Alert text messages on your cell phone. Help put a child abductor out of business for good. Wireless Amber Alerts. A child is calling for help.
My name's Brandon. I'm 9 years old, being alcoholic.
Hi, Brandon.
I'll start drinking with the older kids. And whatever they do, I'll do.
Kids who drink before age 15 are 5 times more likely to have alcohol problems when they're adults. So start talking before they start drinking.
I know it'll start with alcohol. I'm just not sure how it's gonna end.
Welcome back to Case Closed. I'm Charlie Langton with the case of landlord-tenant dysfunction. A recap. Bob is suing Randy for rent, a phone bill, and a whole bunch of other stuff. Randy is countersuing Bob because Bob threw Randy's stuff out on the street. Dysfunction. Now, let's hear what the judge has to say.
You know, your biggest claim here has to do with rent, and before I can order rent, there's got to be some sort of a landlord-tenant relationship
The
between
biggest
the two.
claim here that I have is with the ticket he got in my
That's
name
50
without
bucks.
telling me.
That's $50.
You know,
And he used my name and went to the bank, and I
What?
got statements on that.
that's bull crap.
Well,
That's not even true.
look, fellas, okay?
It's not even true.
Let me kind of decide this and send you on your way, okay? The biggest claim that in terms of money that you're asking for is rent. That's most of what you're asking for is attributable to that.
Well, for storing
No,
his
look, you know,
stuff.
Mr. Doherty, I don't want to hear any more.
Okay.
No more. Before I can order rent, there's got to be a landlord-tenant relationship established between the two of you. And I don't think there was any landlord-tenant relationship. You didn't have any lease. There's some conflict between the two of you about about the money that you were going to pay. I mean, you said $350, including utilities. You kind of agreed to that, Mr. Carroll, but you said you didn't know. So even that's a little bit iffy.
Yeah.
But you lived with him. You lived with him, and if you, it
For
doesn't
over
mean
a
you can't
year.
have a landlord-tenant relationship just because you lived with him. But the agreement between the two of you was of such an informal nature that it's hard for me to put together any sort of landlord-tenant relationship so that I can order damages.
At first, we had a lease,
Yeah.
and that was from '05 to '06 in Roseville.
Okay.
And we was getting along, so we didn't write up another one, that's all.
Do you have that lease with you here today?
The old one, no, I do not, I don't think.
All right. Well, I don't think there's enough of a landlord-tenant relationship here for me to order that you, Mr. Carroll, pay any rent to Mr. Doherty. There was some testimony about this car and whether or not anybody's entitled to any money with respect to that. I can't figure out what the two of you agreed to with respect to that, so I'm not going to order any damages with respect to that. I do think, though, that you should be reimbursed the $50. I think that car at the time belonged to you. If you took the car improperly, and I think you did, and incurred a ticket as a result of that, he was damaged to the extent of $50. So I think you got to pay him the $50 for the ticket. As far as you getting any money in your counterclaim because of the damages that you suffered because your property was gone, number one, I don't think your property was worth $3,000. I really don't. I've seen pictures here of what some of your property looks like, and
Well, I'm
it's just
talking,
not worth $3,000.
Your Honor, I'm talking about my toolboxes,
Well, I don't-
all the accumulation and all the money I put towards that 96 van.
We're not getting
And
into
plus
that.
the
We
car.
are not getting into
car
the
that he
van.
took
We are
from
not
me.
getting into any of that stuff. I
It
don't
would happen
think-
to be legally his,
Mr.
but it was
Carroll, I don't
actually
want to
mine.
hear it. I do not want to hear it. You're not getting any money with respect to that because I don't think your property is worth $3,000. But even if it was, you abandoned the premises. You just left. And if you left and you're not there and it's his house, he's got to do something about that. He can't just have all that property left there, having it take up space, having... He can't just live with your stuff there indefinitely. He's got to do something. So he threw it away. And I think he had every right to throw it away after you left. If you wanted to go live with your girlfriend, you could do that, but then you should have taken your stuff with you when you moved into your girlfriend's apartment or wherever it is she lived. But she probably didn't want it there. That's
I was
probably
just
why you
hanging
didn't
out with
take
my
it.
girlfriend, that's all I was doing.
What?
Your Honor. I was just hanging out with my girlfriend, that's all.
Well,
I was staying with her once in a while, yeah.
Once in a while. You were living with her once in a while. You can't...
I'm still paying rent over there.
I don't think you paid rent in a long time.
And how about the telephone bill?
We're not getting into that, sir. Okay, there's not enough of a landlord-tenant relationship for me to order anything with respect to that. I'll give you the $50 for the ticket. I'll add a filing fee of $45 and a service fee of $27. It's going to be a total of $72, and when you add that to the $52, that's $122, I believe, altogether.
Is there any way I can get-
$122.
is there any way I can get time to pay that? I don't get my social security check till...
Well, that's up to Mr. Doherty. Technically, you've got to pay it today. If Mr. Doherty wants to give you time, that's up to him. But I'm not going to order that one way or the other. The counterclaim is dismissed.
Here's the deal. No written lease, no landlord-tenant, forget it. You're going to lose in court. And here's some common sense stuff. If you borrow your friend's car and get a ticket, pay the ticket. And finally, if you move out of your place, take your stuff, or it may end up in the street. I might have given Bob the $200 phone bill, but you pick your battles. If you find yourself involved in a claim that you can't resolve, small claims court may be the answer. Thanks for watching Case Closed. I'm Charlie Langton.